Welcome to this episode of Litigation Briefs, Media Shorts on Law and Courts. I'm Scott Dodson, a distinguished professor of law at UC Hastings College of the Law, and the director of the Center for Litigation and Courts, which produces this series. When reaching a decision on a question of law, courts look to a variety of factors, such as the meaning of any text, history, and prior court interpretations. Prior court interpretations are called precedent, and synthesizing precedent is one of the primary skills of litigators. But why is precedent so important, and when can it be disregarded? Here to help me with these questions is my guest, Michael Gerhardt, a distinguished professor of law at North Carolina Law School. Michael, welcome to the show.
Thanks for having me.
Let's start with the longstanding common law practice of judges issuing written opinions. Why did they do that?
They did it for a few different reasons. One was it's just the way it always had been done. It's going back to the early days of the British practice, and that became a useful tradition for judges to follow. The second reason is that it allowed them to engage in what we call reasoned elaboration to explain their decisions. Presidents and members of Congress, legislators typically don't give you a brief or long treatise on why they're going to do what they're going to do. But judges, I think, because they're supposed to be independent and not political, try to ground their decisions in reason. And so their opinions allow them to elaborate on their reasons for their decisions. And then lastly, I think it's, of course, important for today's topic because having explained opinions, judges therefore, in a sense, kind of send them off into the future where other judges may follow them or not, but having explained their reasons and having reached an outcome, these cases, otherwise known as precedents, are decided in part to guide future decision-making, and they can provide better guidance if they are put down in writing.
So why would a judge care what another judge has said on an issue or choose to follow what that other judge has said?
Well, some judges don't care, and they go off and do whatever their thing is and may or may not get overruled later. But in theory, and oftentimes in practice, judges care about what other judges do for a couple reasons. One is they want other judges to do the same for them. So you can think of this as a kind of golden rule. Well, if I respect your opinion, then hopefully you'll respect mine. The second reason is judges engage in that practice and follow that practice because it allows the law to become more predictable, consistent, and stable. If judges are not redeciding every question, if things are just not open to litigation every single time the issue comes up, there's going to be a greater degree of stability, consistency, and predictability in the law, and judges by and large value those things.
Does the weight of the precedent or the persuasiveness depend on which judge or court issues it?
Sometimes, but not always. Obviously, in our system of law, the Supreme Court being the highest court in the land is a court whose decisions other institutions, particularly judicial institutions, will follow. Presidents may not always feel bound by what the Supreme Court says, but they're careful not to have direct conflicts most of the time. And the same is true for legislatures. They'll try and abide by what the courts have said, but sometimes they'll directly attack a precedent. The tough thing is if legislatures do that, they know if that case ends up in the Supreme Court will simply overrule the legislature. But in our system, the U.S. Supreme Court it's given a special place in formulating precedents, which it expects others to follow. It doesn't have quite as good a record in following their own precedents as perhaps other courts have been doing.
What about lower court decisions, are they binding?
They're binding up to a point. So in the federal system, we have three basic levels. At the first level, known as the trial court level, we have federal district courts, which might pay attention to what other district courts might have done, particularly to what that particular district court has done, and they will closely follow or try to closely follow what the Court of Appeals above them has said. And they certainly will try and follow the US Supreme Court if that becomes relevant in any particular dispute. The federal courts of appeals will generally try to follow the US Supreme Court. And then within their own circuit, and the circuit courts or courts of appeals are divided into circuits, the Federal Court of Appeals will then perhaps prioritize its own decisions first over those of any circuit that might be conflicting. Other circuit courts or Court of Appeals might provide what are called persuasive opinions. These opinions have persuasive value, but they're not binding. But within a circuit, the courts of appeals will try to follow their own precedent. And when they have trouble doing that, then they may come together in what's called en banc, when all the judges within the circuit, well, the appellate judges within the circuit come together and issue a ruling which is likely to be binding within that circuit for the foreseeable future.
So let's focus on the Supreme Court for a moment. It's true that the court doesn't have to follow its own prior decisions?
Yes, that is unsettling to a lot of people. It may also explain, though, why so many people want to be on the Supreme Court, because they, once they're there, they don't have other people telling them what to do. They get to reverse that and tell other people what to do. And the traditional practice in the Supreme Court is to give some deference or respect for prior decisions, but not completely or let's say blindly. Instead, the Supreme Court again might treat early decisions as having a kind of persuasive value, maybe an informative value, but rarely a binding value.
When does the Supreme Court choose to overrule prior cases?
Well, this is a big question. And so I'll answer it in a couple of different ways. One is the practice on the Supreme Court has been essentially divided along two different paths. One path is where justices might have the outlook that they'll perhaps try to correct anything they think is wrongly decided. That will lead them into conflict with precedent a lot, and too much as far as the other justices are concerned. So other justices will perhaps question precedent, not only when it's been shown to be mistaken, but when there's some other major reason for distrusting it or thinking it might not be valid or of much use anymore. So that's how the courts have generally sort of figured out when cases might be suitable for overruling. But the other thing to keep an eye on is not just what the courts are doing, but what Congress and public interest groups and other people are doing in litigation. They may be trying to push the court. And one of the things we really have to keep an eye on is the confirmation process for Supreme Court justices, because that'll tell us oftentimes what the hot issues are. And presidents may use their power of nominations and the Senate may use its power of confirmation to put people on the Supreme Court that will do what those presidents and senators want. And one of those things they may want is overruling certain precedents.
Can you give me an example of a particularly famous instance in which the court has overruled a prior case?
Sure, I can give you a few famous instances. One of the, most important cases in civil rights coming into the early 20th century was a case called Plessy versus Ferguson, which had upheld state mandated segregation in the public sector. That's obviously extended to schools and other things. That precedent took a major hit in a later case called Brown versus Board of Education, and was partially overruled in Brown. But because Plessy had roots in a sense that extended beyond education, it required other precedents for the Supreme Court to finish the job of overruling Plessy. So Plessy got overruled in a sense in a few cases, the most famous of which was Brown.
That was the separate but equal doctrine?
Yes, in Brown, the Supreme Court unanimously ruled that state mandated segregation of the races in public schools was unconstitutional.
Are there some prior decisions that are worthy of particularly forceful adherence that might resist overruling in the future?
Well, I've written a fair bit on this subject, and I ventured out to answer that question, yes, though I'm not entirely sure how many people would agree with me. But I think there's some Supreme Court precedents that have helped to entrench certain practices or certain foundational doctrines in constitutional law. So early Supreme Court decisions, for example, that recognize the power of judicial review, that is the power of federal courts, particularly US Supreme Court, to review the constitutionality of the actions of small d democratic leaders. That foundation is going nowhere. It's very solid. It's entrenched. There are other decisions of the Supreme Court, I think, that are also similarly establishing foundations which are not going to erode. Perhaps the most famous of which is the Supreme Court decisions upholding the constitutionality of the civil rights of the 1964 Civil Rights Act. That seems very stable and very entrenched. So there are precedents which deal with certain foundational practices, which I think have become so entrenched in our society that they're not likely to get overruled.
Well, Michael, thanks so much for helping us understand how judges use precedent.
Sure. Now, we didn't talk about, of course, the elephant in the room. Should we have, or, you know?
Well, I assume you mean the case of Dobbs, which
Yes.
is potentially going to overrule Roe versus Wade.
Yeah.
Well, since we're recording this episode before the case may be decided, why don't we hold off on that? But I hope I can have you back on a future episode to discuss the result.
I don't expect to be going anywhere. So yeah, happy to do it.
This episode was produced by the Center for Litigation in Courts at UC Hastings College of the Law. If you enjoyed this episode of Litigation Briefs, I hope you'll tune in to future episodes. In fact, I hope you'll consider subscribing to our YouTube channel and audio podcast, which can be accessed through the Center for Litigation in Courts website at sites.uchastings.edu/CLC. While you're at it, encourage a friend to do the same. This is Litigation Briefs. Respectfully submitted, Scott Dodson.